It is still evening. Good evening, Chairman, members of the committee. My name is Brian Blevins. I'm here on behalf of the Texas Trial Lawyers Association, and we are testifying in opposition to the bill. And I think what the gentleman who just testified to is really important to focus in on why we're here. Because what he's talking about is the wrong. He talked about malpractice. And malpractice against a doctor, or malpractice against a dentist, or malpractice against an accountant versus malpractice against a veterinarian. And there's a fundamental difference here. While the wrong, malpractice, negligence, might be the same, the remedy is different. If you sue the doctor for malpractice, you can get mental anguish. You can get compensatory damages. If you sue the accountant wrong, then you can get compensatory damages. If you sue the veterinarian, you can't. This law isn't predicated as some strange livestock-oriented epitome of the 1900s. It actually began in 1891. And it's interesting that at that time our governor was Governor Hogg, and therefore he was the governor at the time that this was first enacted by the Texas State Supreme Court. And what the court said, and what the court has continued to say, even as of 2013, is that animals are only worth what they're worth, your market value. You can't get, whether it's a pet, whether it's a canine dog, whether it's a quarter horse, whether it's a seeing eye dog, whether it's livestock or racing stock, all you can get is the actual value. And so that's the purpose of attorney's fees. If I have a contract to render a service that's worth X and they don't do it, I can get X. But if I can't get attorney's fees, I'm not made whole. And that's the purpose of this statute as it exists. All that can happen, they offered $12,000, the value of the horse. Without the attorney's fees, the offer or an award of $12,000 does not make the wronged person whole, because he or she is going to have to pay attorney's fees. The only way, and that's the truth as to all of the different elements of this statute, which was passed in 1909, is that all of these share one common characteristic. All you can recover under the law is what it's worth, what you're entitled to. And without the award of attorney's fees, you can't make the plaintiff whole. That's the goal. Traditionally, attorney's fees were not recoverable at common law, and that's why we have a statute. And it's either to make the plaintiff whole, or in some cases, you have an instance where the value may be nominal, but the right should be preserved, and we want to balance that. So in this instance, if all that could be recovered was the $12,000, how does that quarter horse owner pursue that claim? How does he do that? Pursue that value if all he can ever get is exactly what he lost. Every dollar that he's paid in attorney's fees simply diminishes what he was able to recover. And so that's why we're in opposition to the bill.
Mr. Chairman.
Yeah, Mr. Sheets.
Yes, Mr. Blevins, what do you have to say about the argument that this is making it difficult for cases to settle because there's no incentive for the plaintiffs to settle?
Not having been involved in the case that we heard about, I don't know at what point in the process they came forward, as Representative Schofield asked, and made the offer of settlement, that $12,000. If they had valued the loss appropriately at the beginning and made an appropriate offer of settlement, they may have been able to cut it off. If it's an $80,000 attorney fee amount, that has to be an hourly. It's a $12,000 horse, so this wasn't a contingency fee practice. So therefore, if at the beginning of the case, the loss had been properly valued, a good faith offer of settlement had been made at a time when we didn't have hundreds and hundreds and hundreds of hours apparently of plaintiff work to do on the case, then I think that would have been able to have been resolved in a much, much more reasonable basis. But without that grant of attorney's fees, how does the quarter horse owner or the pet owner or the canine dog owner, how do they come forward if all they can do is get the value of that actual value of the dog itself or the horse itself?
So how do we get these cases to the point of settlement? Because that's the ultimate goal of this legislation, is find a way to get the parties to a point of resolution, to where we don't have to force people to go into trial, and then also create an incentive for them to go to trial. Because if there's going to be attorney's fees, that creates an incentive to go to trial rather than try to settle out.
I think that, number one, we ought to look and make sure that the statute which provides for the offer of settlement does adequately cover this particular area. I also think that the Rule 91A, possibly on a motion to dismiss, might be an effective tool in some cases. But realistically, I think that this is part, just as if this was there doesn't seem to be a lot of dispute over the value of the animal here. They offered 12, I think the jury awarded 15. So just like how notes are easily valued, I think the parties have to recognize what is that loss, reduce it to the dollar, and make good decisions early on in the case, and that's how they manage litigation risks.
Can you collect attorney's fees in lawyer malpractice cases?
And I'm sorry, what kind?
Can you collect attorney's fees in lawyer malpractice cases involving lawyers?
You can, unless they breach a contract claim, perhaps, because I do have a contract. I don't know if that would allow it. I've never been sued for malpractice.
I don't think you can collect attorney's fees.
No, if I could, Mr. Sheets, on a couple points on that, yes, you can if it's provided within the attorney services contract, because it's a matter of contract, not a matter of negligence or tort law. But I think that we're really focusing on the wrong part here, because to me, this is an issue of underwriting, not an issue of the claim. And if the underwriters, the carriers, know that a measure of damages under Texas law for veterinarians is the attorney's fees, because as you've properly stated, the value of the animal is what it is, then perhaps the carrier for the TVMA or other carriers or insurance companies that provide that service should factor that into their rating and into their measure of damages. I think there are other policies that do cover attorney's fees. I mean, this is not like we don't cover intentional acts or punitive damages arising. This is no esoteric question. There's no prohibition to a carrier factoring this into their underwriting decision, raising premium and making this a part of the measure of damages. So that to me would be the solution, not so much in changing fundamentally what the causes of action are arising from purely property damage loss.
One of the things also that we did see in the statute, which we're not sure is clear, is that because contracts in veterinarian medicine can be an essential part of the provision of care. In other words, you're doing a deal where you house animals, or you enter into a long-term agreement not to treat a specific animal, but a stable of animals, for instance. It wasn't clear whether then if the mismanagement or malpractice or negligence within that contract would also get swept under this and in effect deprive someone of even a breach of contract rights. But that wasn't clear. But realistically, I just think that it was important to recognize the distinction between the right in terms of a malpractice might be similar between the various ones discussed, but the remedy here is very, very different. And the Supreme Court affirmed just in 2013 that in terms of animals, you can only get their actual value. You can't get consequentials. You can't get mental anguish. You can't get those. If we'd like to do that, then that might be a perfectly appropriate remedy, is to give us that broader cause of action for consequential damages, and then it would fit into the category the gentleman described, and we wouldn't need attorney's fees.
Okay. Any other questions?
Give it my best. Thank y'all so very much. Appreciate y'all's patience and your service this evening.
Ms. Barr's got a question.
Yes, Representative.
How common are these suits?
We did look, did a substantial amount of legal research. I think we found perhaps 2 cases as all we could find in the history of since 1909 of the statute on animals. I want to say that one of those cases actually ruled that you can't get attorney's fees. The court in that case actually would not approve attorney's fees and on the malpractice side. And then I honestly, I've forgotten, Representative Farr, what the other one held. But it's that's one, I think the term was strike suits. Again, if there are, they're not making their way to the appellate system. We're not seeing them being reported on at a Court of Appeals level. Thank you.
Mr. Raymond.
Good.
Well, not for you, but then this is your bill?
Yes, sir.
So how many cases are you familiar with?
Just the one that was brought to us.
So then we're familiar with 3 since when?
1909.
And did you search trial courts or just appellate courts?
I've only searched the appellate courts. In terms of published opinions,
Okay,
we only
thank
look
you.
for published opinions.
Well, did Mr. Sheet, what did you research?
We have the same access. That's why I had to make the same point that you can't find the trial cases, especially when you're talking about the early part of the century
That's
or
true.
the last century.
That's true.
Okay, any other questions? If not, Ms. Blevins, we appreciate you being
Thank you.
here.